Good evening. Thank you for tuning in to the Injustice Anywhere radio program. My name is Bruce Fisher. Today is June 30th, 2015. Injustice Anywhere is an all-volunteer organization working to correct wrongful convictions. You can view our main website at injusticeanywhere.org. You can also Google Injustice Anywhere, and you should see our main website right there at the top of the page. When visiting, you will find links to Facebook and Twitter. Please like us on Facebook and follow us on Twitter in order to keep up to date with current events. All of our radio shows are available as podcasts on our radio show page after our live broadcasts. Please spread the word about our station. It would also help us a great deal if you follow our page on Spreaker. You can sign in with Facebook to follow. It only takes a minute. Tonight we'll be discussing the Fairbanks Four case in Alaska. Tonight's guest will be University of Alaska Fairbanks journalism professor Brian O'Donohue. John-Hartman, a 15-year-old high school student, was murdered in Fairbanks, Alaska in 1997. Two young men, George-Frese and Eugene Vent, allegedly confessed to this crime. They also implicated two other young men, Marvin Roberts and Kevin Pease. All four were convicted of Hartman's murder. The accused became known as the Fairbanks Four. In the years following their convictions, Frese and Vent recanted their statements and claimed that their confessions were false. The Alaska Innocence Project has presented new evidence in the form of an affidavit from a man named William Holmes, in which Holmes states that he and another group of teens committed the crime. Marvin Roberts was released on parole this month. The others in the Fairbanks Four continue to serve their sentences. Did controversial confessions, racism, and police misconduct send four innocent men to prison? We'll explore the facts of this case tonight and let you draw your own conclusions. I would now like to introduce tonight's guest. Hi, Brian. Welcome to the show.
Hey, Bruce. Nice to be on.
Very nice to have you. Now, before we get into the details of this case, can you tell our listeners a little bit about yourself? How did you become involved with the case?
I'm a journalism professor, and at the time this crime happened, I was working for the local newspaper here in town, the Fairbanks Daily News Miner, and I did not cover the case. I was covering a Ponzi scheme called World Plus at the time. But I was party to some of our discussions about coverage and the complications of the case. And later I became editorial page editor, and I kept getting these letters from folks in our Yukon River villages. Those are Athabascan. It's part of the native Alaska culture up here. And folks in those villages were just adamant that they thought there was something wrong with the verdicts. They thought the boys had been railroaded. And they were suggesting questions about the case that, in those days we worried a lot about libel. And so I found myself down at the courthouse, trying to check, some of the claims. And the more I looked, the more questions there were.
And that's how you began researching the case?
Yeah, like I say, I was editorial page editor, and then within the year I started teaching. And I thought that this case, sort of looking at settling some of the questions about this case, I thought would make a good semester project in the investigative reporting class, and that was fall 2001.
Okay, very good. Now, this case, I'll be honest, it has not been in our radar here at Injustice Anywhere. It's a brand new case for us. We're looking to you to educate us on the case. I have read through the basic details, and I will highlight the issues that I saw that really stood out to me about this case. But feel free to chime in and add information at any time that I've missed or that I've gotten wrong.
Sure. Yeah.
We have an hour, to do the show, so I would like to start at the beginning and work our way through the case so our listeners can process what has really taken place here with the Fairbanks Four. Now, to start off, Brian, can you give us a brief overview of the crime scene? Where was John Hartman murdered?
Well, he was found unconscious, sprawled on pavement, half across the curb, just off a busy street in downtown Fairbanks, about 2 blocks away from the old police headquarters at the time, and no one observed there was no witnesses to the crime itself, other than people involved. But there was a women's shelter that was right next door. And there was a woman that was smoking a cigarette out on the roof, and she was she'd been a victim of domestic violence, and she heard what she thought was a very serious fight going on in the street below, and felt like one person sounded like they're getting beat up pretty badly, and she went down and told the shelter supervisor. And the woman, they went opened the door and stood outside for a second and didn't hear anything. And the supervisor refused to call police. About an hour and a half later, a motorist was driving along that street and saw John-Hartman, who was still alive but unconscious in the shadows of the street just below, that shelter.
What time of the day did this take place?
Well, the woman heard the fight at approximately 1:30 in the morning, and one of the more interesting pieces of police work narrowed down that time because she was watching the Conan O'Brien show right at the point that David Bowie came on as a guest, and she was not a big fan of David Bowie, and so that's when she went outside to have a cigarette. That's 1:30 in the morning. The motorist comes along. One guy driving, two or three other sisters, and that's about 2:50 in the morning.
Okay. Is Fairbanks a peaceful community?
Well, yeah, I would. Well, I don't know. We have a lot of certainly alcohol-related violence, and we have probably per capita a pretty high rate of murders. But we're talking a handful of murders a year. And it's a small community, so I think most people at the time were extremely shaken by the brutality of this, which, Hartman was left for dead on the street. He, his face and head showed signs of being stopped. He never recovered consciousness and lingered on life support for about 30 hours before he died.
Okay. Well, my reasoning for asking that question wasn't just about the violence, but I'm reading here that the victim was 15 years old. So to me, it stood out that he was out at 1:30 in the morning. Is that a common practice?
Well, actually, when I mentioned that I was part of some of our coverage decisions and coverage discussions at the Newsminer, I mean that's one thing that I brought up right away. I mean, he actually had just turned 15 about 2 weeks before, and what's he doing out at 1:30 in the morning? And he's not reported missing. The next day, or later that evening, the police are still trying to identify him, and they bring his mom to the hospital, and she identifies her son on life support. It just was. It seemed to be not the kind of place you would expect to find a kid like that wandering around that time in the morning.
Right. Now, were there
in October?
Absolutely. Were there any weapons shown to be used, or did the wounds appear to be caused all from just blunt force trauma from punching and kicking?
There's no indication any sort of weapon was used.
Okay.
Yeah, this is a brutal assault. There was a perception, and at least I think two of the people were convicted of a sexual assault in connection with this. By the third trial, with a better attorney, and they looked back at the autopsy records, and it may well be that there was no evidence of sexual assault, and that might have had to do with the victim was found with his pants down around his knees, and this was something right from the beginning. The ambulance drivers noted, and the hospital, then gave him a test for sexual assault. And what came to light several years later during the second trial is that Hartman was wearing pants that were way, way large for him. Just huge, hugely baggy pants. And they belonged to a friend of his, and they're sort of like the mystery of the pants has always been part of this case, and since that point, and so they might have fallen down if he had, say, been running, and there doesn't appear to have been sexual assault, and Marvin Roberts and Kevin Pease, the last two tried, were acquitted of that charge.
Okay, so his pants are much larger than they should be for him. Even if he wasn't running, with a violent assault like that, there's certainly a lot of movement, so I could see a larger pair of pants falling down past the waist anyway. So
this all figures, though, in the sense of kind of shock and horror of the community at the time.
Absolutely.
Where you have a kid just, out downtown, he's stomped, and at least the initial headlines here in my own paper and others were that he'd been raped,
Right. It puts fear in the community, and it's a shocking crime, not only that it's a murder, but you add that to it, and you have yourself some pretty shocking headlines there in Fairbanks.
Mm-hmm.
Now, the police made incredibly quick work of this. From what I'm reading, it took only about 36 hours for the police to make their arrests. George-frese, Eugene Vent, Marvin Roberts, Kevin Pease. They were all in custody within a very short time frame. Were all four of these young men, were they all friends?
Yeah, they were all friends. They all went to the alternative high school in town, which was a largely Native high school. And they had played together. They played basketball together. 3 out of 4 of them were on the basketball team, the school team, within the year before that. One of them, George, was not academically eligible, but he had played with them before. So, yeah, they hung out together, and that night there was a big Native wedding downtown, and this is one of the defining characteristics about the Native community is all the people from the Yukon. Families have connections. Families are related. When one family, a marriage is a really kind of big cause for celebration, and people timed visits to town to go to this wedding, and there are estimates there was 600 plus people that were in and out of the Eagles Hall that night, as for the reception.
It was a big event. Now, 3 out of 4 of the accused are Native American, correct?
3 out of 4 are Native Alaskan, and one, Kevin Pease, has some Native American blood. I think it's like Crow or something like that.
Okay. And that would all... from what I'm
when
reading, that played a role
here,
throughout the case.
We draw a big distinction in the Alaska Native, contingent.
Okay. Now, were all 4 of these boys hanging out together that night? What were they all doing that night? Do they have alibis at the time of the murder at 1:30?
They all crossed paths. And Marvin Roberts, who stands out in this case for many respects, he'd been salutarian of the high school they had all attended. Good kid with a sort of clean record. The only one who owned a car. Indeed, one of the only ones in his crowd who owned a car. He'd paid for that through work as a wildfire fighter with a village crew from Ruby, where he had relatives. And that's high-paying summer work where you're battling these wildfires, and a lot of Native communities have fire teams that cash in on that. Anyway, Marvin had a car, and without the car, the whole police scenario falls apart. And Marvin was known for giving people rides. And he had given one of the other boys a ride earlier that night, that's Eugene Vent. And over the course of the night, he came and went from the wedding several times, taking people places. But he had a number of people that put him there at the wedding at the time that the crime is expected to have occurred, the murder. And so a number of people came forward as alibi witnesses for him.
So Marvin Roberts was at this big-time wedding where 600 guests attended.
Yeah, all of them were present at the wedding at some point. They all went in and out. Most of them, Marvin Roberts shook hands with Pease at one time. They all circulated and were mixing with the same crowd that night. Okay.
So as you said, by crossing paths, they were all there, but they weren't necessarily there together the entire time.
Yeah, no, and one of the things that stuck out about this case from the very beginning is so many people had descriptions of having been with these guys at different points that you would have a case where you have to have 30 or 40 people engaging in a pretty complex deception, or the police just have it wrong.
Okay. How did these young men, how did they get on the police radar that night, and how did they get on the radar so quickly?
Well, it's even faster than you suggested. Eugene Vent, after the big wedding, there was a party several blocks away at a motel that pretty much catered to people coming and going from the village, the Alaska Motor Inn. And the night attendant was having a hell of a time, and kept trying to clear kids out of a room where there was a lot of parties happening. And one of the interesting things is there's a surveillance videotape of the lobby where you see over the course of the night his frustration dealing with these kids that are just raising so much of a ruckus, and tries to clear them out, and then they come back. And at a certain point, he tells the police that he's assaulted by one of them. And so then the police finally come, and he tells them that a kid pulled a gun on him. When the police show up. And so then it's full tilt search for this armed gunman downtown. And Eugene Vent, who had been at the party, who actually shows up in some of that motel surveillance video, kind of drunk and following a woman around, and then following her out to a cab, and the attendant at the motel is like looking at him when the cab takes off, and Vent's left there on the curb. Vent is walking home. After all this, he's been sort of run off from the motel.
What time did the assault what time did that alleged altercation at the hotel take place?
This has taken place about 3:30, something like that, in the morning.
Okay.
And the police are investigating this murder about 4 or 5 blocks away from where they come across Vent, and the police say he ran. Vent says he didn't, and one thing leads to another, and the motel clerk is brought back there and identifies him as, he says, the person who had a gun and assaulted him earlier. And Vent, at that point, is 17 years old, a couple weeks shy of 18, and he's blows a .15, blood alcohol content, or blood .015, whatever it is. It's about twice Alaska's legal limit at the time. And he's taken into the police station, and he's right away a suspect.
Okay, and it's not that even that these four would have been heavy drinkers per se, but there was a big wedding that night, so it gave them all an opportunity to drink quite a bit, did it not?
Yeah, and certainly Alaska has a lot of different problems with drinking, and there's no disputing that both Vent and Vent, we know his blood alcohol because he was actually arrested. Frese, we know spent a bunch of the night partying with friends, was falling down drunk by their descriptions. Is still playing drinking games, until late in the morning, late in the night, and is losing those games, and there's like a game called Up and Down the Yukon or something, and so he's described as being extremely drunk as well, and that's the other person who is said to have confessed.
Was a gun ever discovered from the hotel altercation?
No, and the gun is never discussed by the attendant until after he runs outside and talks to police. So, like, he comes back inside and then is starting to brag about it, but or talk about how they pulled a gun on him. But it really, the motel surveillance tape really suggests that the attendant sort of hyped the whole situation that he was involved in.
Okay. Now, Vent, he's at the police station. He was interrogated first.
Yeah.
Now, these interrogations were recorded, were they not?
They're recorded for the most part, but one of the discrepancies, or one of the flags for potential wrongful confessions in this case, is that right where the police officer, the detective, asked Vent to show him, something specific, the tape runs out. And so we don't have that conversation. And then later there's a drawing produced that indicates that Vent showed the officer where the body, where Hartman was located. And the officer himself drew that diagram and then writes per Vent, on the side of it.
Okay. So how did that, his interrogation, he's a 17-year-old.
Yes.
He's in this interrogation room alone with a single officer, correct?
On and off, mostly a single officer, but from time to time, another officer is bursting in and he's saying things like, Leader Pease is causing trouble tonight, names are being introduced.
Okay.
Different police are taking part in some of these conversations. Vent is interrogated 3 different times over a period of 6 or 7 hours, and he's woken up in between. And the first session, he's saying that he can't remember, and then he's throwing out some names of people that he said that he was meeting that night here or there, and the police catch him in 1 or 2 lies. And then meanwhile, the officer starts saying that they know he was at the scene because there's blood on his shoe. He's wearing sneakers. And don't try to rub it off because we know you were there because his blood is on your shoe. And it's the 16th or 17th time that the officer refers to the blood on the shoe, that Vent goes from having maintained that he doesn't remember to just saying, well, I must have been there if the blood is on my shoe. And
this is after hours of interrogation on a night where he's had no sleep, where he's been at a wedding drinking all night.
Yeah.
Okay.
Yeah.
And what was the official confession? What did he end up telling the police?
Well, he winds up. Both he and Frese give pretty graphic statements about kicking Hartman, and they're not sure why, and Vent says something about maybe they thought he was gay. They make some pretty horrific statements. And to this day, I know that the head of detectives, who was an officer at the time of this case, told me as recently as last summer that all he needs to look at is one of the confessions, and he is confident that they have the right people. And they were applying, again, you got to remember, this is 1997, and not as much was known about false confessions at that time. DNA was just getting traction as something that was revealing failures in the justice system. I think Janet Reno's big statement about it is in 1996. And anyway, if you go back and carefully listen to these confessions and look at where the facts originated, the facts of the case, the facts of the crime originate in detectives' questions. So, from my research into this, the confessions just don't tell us anything. The confessions don't offer convincing evidence, but they also don't clear these guys. The confessions just don't contribute anything. So you got to look at other things in this case.
Now, with Eugene Vent, the few clips I did see online, to me, he was clearly led by the interrogator. He had no idea what happened that night, from what I could tell. But when it comes down to it, that confession hits a jury at a courtroom, and it's very powerful, regardless of what you and I think happened in that room. And that's why wrongful convictions that occur due to these false confessions, it's a major problem we have in the system, and it's certainly something that I truly believe came up here. So after I was looking at these confessions, I started looking for other evidence to say, okay, if you throw these out, do they still have a case? And the case, you take away the confessions, it's incredibly weak. It's weak anyway. But if you remove this, it becomes really hard for me to see a conviction. But we'll move along through the case. How did George-Frese, how did he end up at the police station?
George-Frese shows up at the hospital the next day in mid-afternoon, complaining about injuring his ankle in a fight that he can't recall because he was drinking. And in his first sort of contacts with the triage nurse, she says, "Are we going to see the person that was involved in the fight?" And Frese makes some sort of comment about, "No, I don't think you'll be seeing him." And the nurse is aware of the kid that's upstairs in the hospital on life support, because we're now talking roughly 12 hours after Hartman the medics first responded to Hartman. And so she and and they notify a detective who's in the hospital at that point, and the detective makes contact with Frese, and they talk Frese and his girlfriend into. She goes home and gets Frese's boots and brings them back, and then the detective and a nurse are both. Take them up to where Hartman is still on life support, and they're looking at the bruises on his face, and they're looking at the boot, and they decide that this is a pretty likely match.
That's how they match the boot to the crime?
Well, that's what confirmed their opinion that hey, we've got a guy here that hurt his ankle, and he goes to that same school as Vent did, and one thing leads to another, and they persuade Frese to come to the police station when he's discharged. He hasn't actually broken his ankle, and they take him to the police station. And on the way to the police station, they drive through the crime scene. That's documented, and then they start on the interrogation with him, again, as you mentioned before, the police are laying out scenarios. When the individual is saying, well, I don't really remember, the police are suggesting, well, isn't this what happened, or isn't that what happened? And that sort of thing today, even by the leading interrogation trainers for police, will just tell you when you're dealing with someone who's impaired, you got to be very, very careful in the extent to which you plant information as opposed to just carefully asking, what do you remember? Let's go back to where you do remember, and just collect the details that they have to give rather than confusing the situation with these scenarios.
I don't know if you're familiar with the Ryan Ferguson case, but it's another textbook example of how not to interrogate somebody. Ryan spent 10 years in prison due to another suspect giving a false confession, and he was fed information much like the accused were fed information in this case. So we can learn from cases, moving from case to case. A lot of these wrongful convictions have similarities. Now,
yes, yeah.
How did George-Frese actually hurt his ankle?
We know that he wrestled with various people that night. We know that he, about 5 or 6 in the morning, he's tussling with somebody right outside his apartment. He doesn't know, or at least he within about a day, he was the next time the police did not arrest him right away. The police let him go home that night. Vent they detained. George-Frese they sent back home, and the very next time they contacted him, he's telling the officer none of this happened. The officer's urging his girlfriend to come forward, and he's saying it didn't happen. They all pled innocent at the arraignments about 2 weeks later, and by the time the trials rolled, when the grand jury was first considering evidence, the prosecutor assured them that that either Vent or Frese would turn state's evidence because the two had already confessed. Okay,
so Frese at the emergency room, he's just trying to be cool and saying, "Oh, I got in a fight. You'll never believe what happened to the other guy," sort of thing.
Well, in the very least, he's saying, "Yeah, I heard it in a fight," and no, I don't think you'll see the other guy,
It was bad timing, really, is what it comes down to.
Well, certainly, again, it's a situation where what he said was pretty ambiguous, and the knowing that you've got this kid upstairs dying, it's understandable that
oh, sure. It was actually, it started off as good investigative work, if you ask me, in the beginning, certainly. Now, I've read through some websites here, and they do note cultural issues when it came to the interrogations. I've read here that Native Alaskans are naturally, they have respect for authority figures, so they're uncomfortable telling authority that they are outright wrong. Do you think that played a direct role in these interrogations?
I've heard that said, and I don't know what to say about that. Again, if you really carefully look at the interrogations, I think you will find that you're dealing with some drunken folks that don't have a good memory of what was happening, and whatever they had to say is tainted by the questions. You will hear a lot of sort of sweeping statements about natives are this way, or and I just find that there is individual as anyone, and those tend to be as just generalizations.
Okay. So you put more weight on the police misconduct and lack of evidence than you do on any cultural issues.
I think so. I mean, maybe they were a little slow to ask for lawyers. Maybe they were a little less assertive but I think that their circumstances are more shaped by maybe the coming from the lower economic side of town than the native cultural heritage, at least with respect to this initial sort of contact with the police all the way around.
Okay. Now let's bring all this...
You don't have anyone lawyering up and saying, I'm not giving a statement. You don't have Vent, really standing up for his right to have a parent present,
Sure. You see this often in cases. People are often not educated in how to respond to police bringing you in for an interrogation because it's something you never dreamed that you're going to be a part of. But in reality, if everybody was educated on what to do, a lot of these things could be prevented. But it's not their fault. People should not be expected to know these things when they're taken into a police station. It's generally something, sadly, that they learn that they should have possibly done after something goes wrong. Now, let's wrap all this up. Let's put these together. Kevin Pease and Marvin Roberts are the other two. How did they end up at the police station, and how did they put all four of these together, all four of these young men together?
Okay, Kevin Pease is about 3 o'clock in the morning. Is out. He's at his mother's house, and they're having a big argument. And he, flips over some plants and maybe tosses some furniture around. And he's a kid that has had a lot of run-ins with police. He's been picked up as a juvenile for an armed robbery. His father died in pretty violent circumstances, within the prior year, and he's a kid that's got quite a reputation. He's big. He had kicked apart the inside of a police car, in a prior arrest. So anyway, the 911 call goes out that his mother says that he's busting up the house, and the police are looking for him that night. Right in the midst of all these other things going down, the discovery of this, likely fatal, victim a few blocks away. You have Pease, and the police are being summoned to his mom's house. So they're already looking for him. Marvin Roberts is at a certain point during the interrogation with Vent, they are pull out the high school yearbook, and they're going through and talking to him about who his friends are. And Marvin Roberts had given Vent a ride earlier that night, and he comes up as a person who has a car, and the next thing you know, that he's on their list to look at.
And he's a key factor because he's the only one with the car.
Yep. The boy with the car. I think I might have written a story with that name at one point.
I've seen multiple reports that the last two were implicated by the first two. How did that really happen? What were the they pointed them out in the yearbook? They said they were friends. Did they actually elaborate in their false confession that they were part of the crime?
Yes, they're rolled into the confessions. They're rolled into the scenarios the police are offering. Who did what? Was Marvin driving? Where were you sitting? And these confessions very much drove the case.
Okay.
And so if you move past the confessions and you look at them, and it took us about 1.5 years to actually get a hold of the full transcripts, because the portions of them were suppressed. And I should mention that all these years that I've looked at it, it's been with the help of students. And I had a student that just went above and beyond and went down and camped out at the Court of Appeals in Anchorage the second year we were looking at this for about 3 days, and just started going through all the appellate files and found the full transcripts of the confessions from the arguments that led to the suppression of portions of them. But the fact that a portion of a confession is suppressed just plants even more doubt in the jury's mind, about what's being, covered up.
Absolutely.
Yeah.
Go on.
I had another student who was, if I could just mention, who was a former Coast Guard military police officer. And really early on, he zeroed in on this was a beating death. There should be physical evidence. And so we were looking really hard of what sort of physical evidence, was collected and existed. And the police did send away a ton of different things for testing. Everything from Frese's boot to Kevin Pease's jacket, which had some blood stains, all kinds of, fingerprints collected. And here is where, in my view, the investigation sort of starts to go off the rails. When the test results started coming back 3 or 4 months later, everything is negative. The boots can't be matched to anything. The blood turns out to be Kevin Pease's own blood from a fight who knows when. The fingerprints don't match the victim. They can't even put Marvin Roberts in his own car because, as the crime technician later told us, the car was so dirty and grimy inside that, nothing, they just didn't collect anything linking the victim to the suspects or the suspects to the crime.
Nothing at all. So they were clinging to these confessions.
Yes. And so then that leads to the most misleading aspect of what was presented at trial, and that's that the crime lab could not match Frese's boot, but the crime lab returned to the police a print of the bottom of one of Frese's boots, and the police and the prosecutors, the weekend before the first trial, took photographs of Hartman's face that they had taken at the hospital and were taken without any sort of ruler or sort of measurement, and they took the boot prints and they made a bunch of transparencies and constructed an exhibit that could be flipped, showing different pieces of tread overlapping marks in Hartman's face. And this thing, was attacked by witnesses at trial, some experts on the defense side, but it really is something that is extremely misleading and not scientifically based, and was allowed into evidence, and it is very prejudicial.
It shouldn't have been allowed into evidence. It was based on no scientific fact whatsoever.
Yeah,
I'm looking at the trials. On the trials, before we get in deeper into the trials, they were tried separately. You have 3 trials. Why were the first 2 tried separately and then the last 2 tried together? How did all that work out?
Well, if you think that you've got someone that's going to testify against co-defendants, my understanding is legally they cannot be tried together. So right off the bat, they think that either Frese or Vent is going to turn state's evidence, and so they're going to try them separately. And then Roberts and Vent were offered deals of 5 years or less in return for their testimony, and both Roberts and Vent spurned those offers, which when I talked about this with friends who worked for the Chicago Tribune, during some of those some of their real great criminal investigations, one of them stopped me and he just said, "Wait a minute, you got 4 kids that are facing serious time. 2 of them are said to have confessed, and yet nobody is turning state's evidence." He's like, that just does not happen.
Sure.
You do not get people looking at long sentences, and somebody doesn't rush to cut a deal.
Now, is the same evidence presented at all 3 trials?
No, and it's each one was shaded a little differently. A lot of the same witnesses testified, and what was really useful for us, as I've looked back at this case with students, is we had the full records of 3 trials to kind of compare statements and to look for discrepancies. And by the 3rd trial, where Marvin Roberts in particular and Pease had the best defense, they had private attorneys, hired on both sides, and the Native community in the villages where Roberts came from had stepped forward and hired the same attorney who got Joe Hazelwood, the captain of the Exxon Valdez, off with community service. Alaska's one of Alaska's most prominent defense lawyers represented Marvin Roberts, and at that point, though, you had sort of a snowball effect, and even though more and more discrepancies are coming out, including the distance that a key witness was standing from an assault that he claimed to see.
Right,
and
right. I want to get to that too, because that was a key in all the trials, I believe. Now, I'm looking at this whole thing. After the first trial, they get a conviction. Did that make it impossible for the next three to get fair trials? How did they possibly get an honest jury pool after that first conviction?
Well, all three trials were moved from Fairbanks. They're the only trials since statehood that have been moved out of Fairbanks, and they were moved down to Anchorage. And that's 400 miles away, and that was done because of all the pretrial publicity, because with the challenges to the confessions and some other things, there was about a 2-year delay in these guys actually first coming to trial. So I think that took care of most of that.
Okay. Now, let's get to that witness, Arlo Olson. He was a gentleman. He was a guest at the wedding reception, and he claimed to see an assault outside. Is that correct?
Yeah, he was not only a guest, he was heavily imbibing of spirits by his own testimony. He claimed that he didn't like to dance until he was half shot, and so his girlfriend was really hassling him to dance, and so he was drinking quite a bit, and there's a lot on the record about how much he drank, and anyway, he went outside for a cigarette, and it was really hot, and a lot of people are standing on the front steps of this old Eagles Hall, and he says he heard someone say, "Hey, look, fight," and he looked up, and down the street he claims to have observed a robbery of this one of the wedding guests who had left to go walk to another bar downtown. And what is a fact is that a guest had left and gone to a bar downtown and got mugged on the way and came walking back to the wedding. And when he came walking back to the wedding, there was a 911 call placed from that Eagles Hall, and that becomes about the one-time certain event of the whole night. And so however long it takes a person to walk about 2 blocks back from where they've been knocked down is the one-time reference for this assault the police claimed involved the same group of kids, who then continued back in the car and continued another half mile and came upon Hartman and then just randomly assaulted Hartman.
Because Arlo Olson's, his testimony was used in all three trials, correct?
Oh, yeah. He becomes the state's key witness. He's the only person who witnessed anyone doing anything that night that was could be associated with violence.
But to me, it's very interesting because he witnessed another assault that had nothing to do with the murder that these 4 are being tried for, and his testimony is incredibly powerful. How was it that 3 different juries took his statements about another assault and just assumed, well, if those 4 were at that one, they must have killed this other kid?
His appearance on the witness stand is, to me, the thing that is most egregious about the way the prosecution went after these guys. It was known. Well, no, let me say, the grand jurors it was presented to grand jurors that Arlo, and his name is Arlo Olson, was standing perhaps across the parking lot from where the assault occurred. By the first trial, the distance was being placed at more like 100 feet or so. By the third trial, the third and final trial, the defense, which, as I say, was the best legal team, thinks to call the actual police officer who had investigated that assault and put him on the witness stand. And under oath, he admits that he'd taken a roller measurement and measured the distance between where Arlo was standing and where the victim, was assaulted up the street, and it was 550 feet away.
So he saw a group of people attacking somebody, and we do have an actual victim there, so we know that an assault took place. but he's a good distance away to be able to pick somebody up.
This is more than a football field away.
How and why would he have accused these four?
Arlo is a piece of work, and he immediately after the trials, or not long after the trials, he tells an investigator for the defense that he was threatened with perjury, and just told the police what they wanted to hear. During one of the appeals, he stood back on the witness stand and says no, he lied when he said that, and that what he testified in the trials is what was the case. I interviewed him between 2003 and 2004 multiple times, and I got him to call me at my office and tape some of those conversations. And he acknowledged just not knowing what happened that night, and said that the police had pretty much persuaded him of what had occurred, and that and then when he tried to back out of it, they told him a lot of people had witnessed it and that he'd have company, and when he tried to back out of it, they threatened him with perjury. Arlo later was put on the witness stand again, and the judge said basically that he didn't know what to credit with Arlo, and now Arlo is showing up on the witness list of the Innocence Project, which is attempting to overturn the verdicts in this case.
So, he's given multiple statements, but how early on did that happen? Have his affidavits or any witness statements like this recanting, have they been part of appeals in the past? No, he has never given any kind of sworn recantation up till now. Okay.
Nothing on the record indicates that he has given any sworn statement right now that counters his testimony in three different trials. That testimony has a lot of variance in it, and as I say, he's very vague about the distance that he's standing from it. And I think what you might have been alluding to before is that Arlo was native. Arlo was from the is Athabascan along with these other guys. And from the grand jury forward, a number of comments from jurors seem to allude to giving more sort of credibility to his testimony because he was testifying against a fellow native, and that for some reason that was seen as being a brave and courageous thing to do. And this is something that has really offended, people in the Native community. The idea that, what's that say? That a black person or a white person is especially brave if they testify that they saw a black or white person, commit a crime. That's what a citizen should do, right? So why would there be anything unusual credence attached to someone just because he's identifying a fellow native?
Right.
And meanwhile, you have all these other fellow natives that are alibi witnesses, and somehow you discount them. And the prosecutor in the third trial gave a sort of closing argument where he just cemented his image as a bigot in the minds of many, in the Native community here, because he compared the alibi witnesses to the, fellow slaves with Spartacus. That when the Romans were demanding that they identify Spartacus, the leader of the rebellion, Spartacus is about to stand up, and then someone stands up and says, "I am Spartacus," and someone else stands up and says, "I am Spartacus," and essentially sacrificing themselves to save the other. And that argument is something that I was looking into this case and talking about it with a group in Tanana. I call them the Tanana Detectives. They were a little community group in the village of Tanana that was met in the basement of the health clinic there, and they were going through the trial transcripts. And when they brought up this whole thing about Spartacus, they knew what page it was on in the trial transcript. Page 3,000 something. The lady wrote it in a sticky note and gave it to me. This case has been very, very hard for the Native community to accept the system's refusal to acknowledge what they perceive as just unfair trials.
And it's been going on for quite some time now, so it's going to take a long time to heal from this, even if it is eventually resolved. Now, I'm looking at the three trials, and of course we know they were all convicted. The evidence I see is Arlo Olson, the two confessions, and some unscientific evidence of the shoe prints on the victim's face. Was there anything else I missed as far as evidence goes in these three trials?
You know, this case has all the hallmarks of wrongful convictions, short of evidence, physical evidence that would prove that these verdicts are wrong. So let me point you towards the what has not yet made it into the record, what has occupied our courts for the last 18 months.
Sure. I mean, that's what I want to get into is the new evidence that is currently there. So this is perfect.
Yes. Another guy who used to live in Fairbanks at the time, and he and his friends were convicted of a terrible murder conspiracy, failed drug ring takeover back in 2000. This happened just before Christmas in 2002. They were convicted in 2004, and two people are serving what amounts to life sentences for this. William Holmes down in California, and Jason Wallace here in Alaska. Jason Wallace turned state's evidence against Holmes, and they both killed at least two people in at least three people in two different states. Holmes in 2012 came forward to the Innocence Project and has given sworn statements and confessed that he and some of his high school friends killed John-Hartman one night in high school when they were just cruising around looking for drunk natives to beat up, which, according to his account, is something that they did a couple times that summer in high school, just for fun. Now, here is the thing. That's all on the record. Also on the record, but under seal before the court, is statements from Holmes's old partner, Jason Wallace. Because you could discount what Holmes had to say. Maybe he's just messing around with the system up here with the DA.
Right. What does he have to lose at this point? Right.
Yeah, he's serving double life. Well, 10 years ago, his partner, when they were getting ready for trial, Jason Wallace, made statements about Hartman's murder. We know that much. Those statements are against his interest, according to what is public about a file in this case that is still under review. And our appellate court is right now, since December, been reviewing whether to take arguments against the release of statements that Jason Wallace made to his public defender at the time. And those statements, from what I know about this case, are going to largely corroborate what William Holmes had to say 10 years later. And that, in a case without physical evidence, is I think, going to be the strongest evidence of who killed John Hartman.
Now, this is evidence that has been discovered due to the work from the Alaska Innocence Project?
There were leaks about this 10 years ago, and lots of odd sort of comments that we used to get from Wallace's old attorney about, he didn't want us to talk to him, but keep asking those questions. When the Innocence Project, got going in Alaska in 2008, they started reviewing all that was known, and we shared all of our files, and we now know that an investigator for the state, for the Public Defender's Office, later became a founding board member of the Alaska Innocence Project, and he is likely the source of the leads about Jason Wallace's statements as a public defender, because there's been all this fight about Jason Wallace's privilege claims, and all of it's happened behind closed doors. And I've been in the hallways, with just a lot of supporters of the Fairbanks Four, packing the hallways, staring at the troopers guarding the door, waiting to hear what's going to happen. And to date, all the hearings on this sealed brief have been closed. And during the public session parts of it, sometimes another reporter and myself are the only ones present.
Now, what's it going to take to get this information released? And does it need to be publicly released to be able to be used in this case?
I think so. I think it has to. I think that, the judges, you can read between the lines of a lot of the judges' decisions on procedural issues related to this matter, and we published extensively about it. If you Google, the Fairbanks Four and Newsminer, NEWSMINER, I think you'll find a ton of stories about this case that, that I've written, and it's the sort of thing, it's uncomfortable evidence. It's privileged communications between an attorney and client, but those communications shed light on a wrongful conviction. And so there's a lot of precedents being argued in terms of, can the state withhold something once it's in the record from others who needed to exonerate themselves?
Sure.
And that's pretty significant.
Now, they do now have a sworn affidavit from Arlo Olson recanting his testimony?
There's a rumor that they have that Arlo is on the witness list for the Innocence Project.
Okay.
Nothing's been filed that I can see.
And what is the current status of the case? Is there an appeal available? Do they have to file motions? Where do they stand right now?
In September 2013, the Innocence Project filed for exonerations. They filed for declarations of actual innocence on behalf of 3 out of 4 of them, and this was based upon Holmes' statement. In support of that statement, they had a number of affidavits from some other folks that had different kinds of information. They cited some of our findings. But there also was a sealed brief filed with that refers to supporting statements from, Jason Wallace, Holmes' old partner. And that part of the case has continued behind closed doors while they have moved forward on other issues, and they've set a non-jury hearing of all the evidence for this coming fall on what happens to coincide with the 20th anniversary of the 18th anniversary of Hartman's death.
Now, how has the Alaska media handled this new evidence and the speculation that this case may have gone completely wrong? Has the media tide kind of changed over the last year or so?
Well, there's always been coverage of the protests. I mean, there's the Native community has been, every time there's a Native convention in town, there's usually been some sort of march or street protest. My students have done, photographs and video reports through the years of these different, tribal sort of, protests. And now we have the steady drumbeat of hearings leading up to this fall, evidentiary hearing, and it's getting more and more coverage. I mean, the last couple hearings, you had TV crews flying up from Anchorage, including another former UAF journalism student who's now a TV reporter. And my students are working in all aspects of media up here in the state now, and all, many of them were introduced to this case while they were here at the University of Alaska. And I think there's a lot of broad interest and somewhat of disbelief that we're getting to the day when we may learn more about John Hartman's murder.
Now, is there a date set for the fall, the evidentiary hearing?
The week of October 5th, and then the following week.
Okay, so we'll keep that on the radar. Yeah, for everything I've read and everything you've told me tonight, you and your students have done just an outstanding job researching this case, and I'm sure that your eyes are on it and can't wait for that date in October.
For a long time, I thought that all we'd ever find was we could document the problems with this case, and the reason that people had doubts and the Innocence Project are the ones that really put together the pieces in a big way that I hope will lead to justice for John Hartman.
Now, one of the 4 is currently on parole. When are the other 3 eligible for parole?
Eugene Vent has parole for 2019. The other two are just off the boards. I mean, Kevin Pease is serving 79 years, and George is sentenced to 77. And yet they're both pretty optimistic at this point. I mean, I visited Frese in prison in April, and they're all back here in Alaska, and they're all just feel like their day is going to come. And I think that what may differentiate them from a lot of individuals in a circumstance like this is that the four of them have felt like they are sharing. It's not like, why in the world did this happen to me? It's like, this happened to us. And there's been something encouraging about knowing that someone else is sharing this. Someone that literally you go all the way back to high school with, and they refer to that a lot. And this whole Fairbanks Four campaign, it's Free the Fairbanks Four. There's Free the Fairbanks Four pages and Facebook, and that's run by a one-time news writing student who is just a real force in her own right. And when she just really got worked up about this, she's launched what she admits is an advocacy campaign, and that has generated a lot of letters and a lot of attention, a lot of support for these guys from about 2010 forward that I think has really energized this case as well.
I mean, I certainly see a reason for optimism. To me, the state's only witness really that had any bearing at all, his testimony to me has been completely discredited. Now we have possible evidence not only of exonerating them, but also finding out who really committed the crime, which I always say you shouldn't have to solve your crime to prove your innocence, but if the investigation leads to the actual killers, that's obviously a very optimistic outcome.
Well, and I think the last point I would make is that I think that this case has national implications in that the stakes of information withheld because of legal convention is really going to be glaring for all to see. And the idea that you might have knowledge of a wrongful conviction, that you feel some sort of there has to be a way to make that information known to authorities. Alaska amended its bar rules. It's one of two states that had done this at the time. This is 2009, where an attorney could come forward with, if he believed it was a wrongful conviction and it was reasonably necessary for him to waive privilege, that the attorney themselves could waive privilege. It was discretionary, though. Something like that should be mandatory, that if you are sitting on information that exonerates someone else that is wrongfully convicted, there should be some mechanism, some process that you turn that over to a legal tribunal, or at least make the state aware of it in some way that it can be investigated.
Absolutely.
I mean, and I would hope that something like that will come out of this. The sheer circumstances of four kids who have lost their 20s and 30s largely, if it's documented, as I believe, that these are wrongful convictions, then we've got to look at what went wrong with the system, because this has been appealed up and down to our Supreme Court, a number of times, and individually aspects of this case have been held to be harmless error. Well, cumulatively, it's pretty overwhelming that these guys were ever convicted. And if it turns out that there was folks within the legal system that were aware of pertinent, exonerating information, I think that is going to cause a lot of scrutiny.
Certainly. And you can't give the lost years back. I always say that wrongful convictions cause irreparable damage. There's some damage that just cannot be corrected. But
absolutely,
if some reform can come from this and something positive can come out of it, at least there's something to take from this case as we move forward that's good. It's very difficult to find something good when you see four people lose, like you said, their 20s and 30s. But they need to prevent this from happening again to another set of teenagers down the line.
Absolutely, yeah.
I really want to thank you for coming on the show tonight. You truly have provided a great deal of information on the case. I know there's much more that we did not discuss tonight to learn about the case. I know you mentioned a couple websites. Can you give us the key sites that we should go visit to learn more about the case, and also the Facebook page?
I would go to the Fairbanks Daily Newsminer. That's newsminer.com. And just search for Hartman, and you will find tremendous amounts of information about it. If you look for UAF journalism and Hartman, you'll find some current and former student sites that have a lot of information about it. KUAC Radio here in Fairbanks has a lot of different audio reports about it. Dan Bross has just done some really good reporting. And then if you really want to get involved, there is the Free the Fairbanks Four campaign. You can search for that term in Facebook, and you'll find their pages. Or Alaska Innocence Project can use your support. I mean, they have one attorney, he's the executive director, lone one-man band, Bill Overly, and he's just done a lot of good work with this.
Sounds good. Very good. Hopefully we can talk again in October after that evidentiary hearing, and hopefully we hear some good news. But thanks again for being on.
Before that, and I'll let you know. All right.
Sounds good. Thank you, Brian.
Thank you. Bye.
Please visit injusticeanywhere.org to learn more about our featured cases, and please visit those websites Brian mentioned to learn more about tonight's case. Please take a moment to click on the Club 22 logo at the bottom of our homepage at injusticeanywhere.org to learn more about Lauren Hill. Once you do, you may feel the need to help her cause. I certainly know I did. Please join us again next week, same time and channel. Thank you for tuning in. Good night.